So we've got a basic evolution of international law, but that doesn't answer the basic question of what is international law. In a dispute between France and Turkey at the PCIJ, the Permanent Court of International Justice, in 1927, the court said the following about international law, quote, "International law governs relations between independent states. The rules of law binding upon states therefore emanate from their own free will as expressed in conventions or by usages generally accepted as expressing principles of law and established in order to regulate the relations between these coexisting independent communities or with a view to the achievement of common aims. Restrictions upon the independence of states therefore cannot be presumed." So the court basically said that states were free to do anything not expressly prohibited by international law. This is typically considered the traditional view of international law. There are many other views of international law. They include the New Haven School, socialist, radical feminist theory, mainstream realist, pragmatist. We'll mainly stick with the traditional view, but an example of another view is the mainstream realist pragmatist view, and it goes on that the reality of international law is basically that it works and that we need not go into theories of whether it's accepted as law or not and how or whether it is disobeyed or not. Of this theory, one of the great Polish-British lawyers of the early to mid-20th century, Hirsch Lauterpacht, said judges should basically be responsible for filling the gaps left by norms through the application of general and moral principles of law. The important interpretive role assigned to judges would obviate the need for grand theories of international law. So what are some key features of public international law, both traditional and new? Some of the hallmark features of classic public international law include that there isn't a hierarchy between states. All states are meant to be equal, not one over the other. That sovereign states are will sovereign. That there is reciprocity between states, meaning that the benefits conferred by one state onto another should be granted in kind back to that state by the other state. That they should cooperate. Overlaid on the classical public international law structure of state versus state and this horizontal structure is a system of evolving rules and principles and values and relations between a range of participants in the current world order. Some of these new features include new actors, individuals, NGOs, international organizations, armed groups, terrorist groups. They all now participate and affect the international system. Also, new norms and values. We have an interest in human rights, control and use of force, cyber law, space law. We are reinterpreting rules and values, including sovereign immunity. We have new institutions and new courts like the International Criminal Court and the International Criminal Tribunal for the former Yugoslavia. Now, what is the relationship between the international law that we've been discussing and domestic law? Here's an example. A foreign ship may be captured and the foreign crew tried in a domestic court for, say, ignoring customs laws. The domestic law prescribes a custom enforcement zone of X miles, but the defendant foreign crew argues that international law permits a custom zone of X minus 4 miles and that the ship, when it was captured, had not yet entered into the zone of enforcement justified under international law. So whose law is meant to apply? There are a couple of theories that explain the reception of international law in domestic courts. In monist states, all law is the same. Law is a single entity and it is irrelevant whether international or domestic. There can be only one system of law. In the case of a conflict between international and domestic law, the international law prevails because it is supreme. And in a monist system, treaties don't need to be transformed into domestic law because they already exist. This is also known as the doctrine of incorporation. So in the example, international law would apply and the crew wouldn't be guilty in a monist state. Germany is an example of a monist state. The German constitution says that international law is directly applicable and takes precedent over German domestic law. Now contrast dualist states. In dualist states, international law and domestic law are separate legal systems. Dualism considers international law and national law as independent of each other, and both systems are regarded as mutually exclusive and therefore generally are not able to conflict with each other. They sort of exist side by side within different spheres, the international sphere and the domestic sphere, meaning treaties in a dualist state are not what we call self-executing and instead require implementing legislation. We call that the doctrine of transformation. Think, for example, the Genocide Convention in the United States. We can't just rely on the convention in the US. We have to have implementing legislation. USC 18 USC 1091. Also, think about the supremacy clause of our Constitution. Article 4, Clause 2 of the U.S. Constitution establishes that our Constitution and federal laws made pursuant to it and the treaties made under its authority constitute the supreme law of the land. So in a conflict in a domestic court, in a dualist state, domestic law would be applied in preference to international. So in our example of the captured crew, domestic law would apply and the crew would be guilty. Who has the authority to make international law? There is no world legislature. States make international law and not individuals. One of the purposes of the UN since its founding has been the codification of customary international law, so sort of the reducing to writing of international law in an effort to make international law have a more rules-based approach. Now, in order to facilitate that, the UN established in 1947 the International Law Commission, which is composed of 34 international lawyers elected by the General Assembly in their individual capacity, but who are meant to represent the world's legal systems, and they work to codify international law, which is what we call lex lata. So, reduction to agreements and treaties and conventions of what international law is. But they also work on what they hope the law will be in the future, what it's not yet, but what they hope it will be in the future. We call that soft law or lex ferenda. Another important institution with the interpretation of international law is the International Court of Justice, or the ICJ. It was set up in the UN Charter in Chapter 14 as the principal judicial organ of the United Nations. Now, some of the basics of the court include that there are 15 judges elected by the UN General Assembly and the Security Council. They're elected via what we call comity, which is accepted international practice that certain countries are always represented. So, for example, China, France, the US, and the UK always have a seat on the court. Judges have 9-year terms and are re-electable. And in terms of when the ICJ can accept jurisdiction in a dispute, being a member of the UN is not enough. The states have to consent to the court's jurisdiction, and they can do that in a number of ways. So finally, actual sources of international law. Where do we find international law? According to ICJ Statute Article 38, there are 4 main sources of international law, and they include international conventions, custom, general principles of law, and judicial decisions and the teachings of the most highly qualified publicists. We'll take each of those in turn. Treaties. First provision from ICJ Statute 38 on sources of international law. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. This is basically an old-fashioned way of saying treaties. This is the most specific form of legal obligation between states. Sovereigns enter into these agreements and agree to be bound by their terms. They're like contracts. According to the Vienna Convention on the Law of Treaties, a treaty means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or 2 or more related instruments. So treaties might also cover documents called conventions, pacts, protocols, charters, covenants, exchanges of notes, and memorandum of understanding. But they only apply to those who are parties to them, and are subject to permissible reservations. Reservations mean that when a country ratifies a treaty, it can say, I agree to all of the terms except this particular one. So, for example, the Republic of Turkey, when signing on to the Hague Convention on Service Abroad of extrajudicial documents in civil or commercial matters, said, I will not agree to the term which says that you can serve process by mail. Now, treaties can be in the form of bilateral agreements, so between two countries. They can be multilateral, many countries. They can be a framework agreement, meaning that the big picture is agreed upon in a treaty, and then states develop the more nuanced aspects outside of the treaty. Treaties are gradually replacing customary international law, so reducing to writing what used to be custom. And since 1945, as we discussed, there has been this shift in focus to codify international law through specifically the International Law Commission.